So my submission on this legal precedent would be crucial. I'll be making the submission that as far as the Bas Kakar case is concerned, PLD 2000 Supreme Court, that is clearly distinguishable in terms of the law which was involved, the Contempt of Court Act 2012. But as far as Ghulam Muhyiddin case is concerned, which concerned the Review Act which was part, I would be respectfully submitting before your lordship that parts of those judgments have to be revisited. Not the entire judgment, but parts of that. Let me come to my...
have to be
revisited. But only parts of that judgment, my lord. My lord, if I may take your lordship to my first submission. And my first submission, as his lordship, what I've done is that I framed the questions and then I framed short answers and then I'll make submission. Let me just read the question. The first question is, and this is a question I think which has been filling her ladyship, Justice Aisha Malik, whether the term law occurring in Article 191 Constitution 1973 includes acts of parliament, whether the term law occurring in Article 191 itself confers legislative competence and or requires legislative competence to be based on some other provision of the Constitution and or legislative entity in the fourth schedule. If the Parliament has the power to enact a law, enact such a law, then what are the limitations of such a law? My lord, if your lordships may turn to the third page of the brief note which I've given your lordship, and the heading is B, where I deal with this question. Now, my lord, the term subject to law. Now, question has occurred and repeatedly been asked, is this conferment or is this restriction? What I would be submitting before your lordship is that it is both. It has two parts, subject to and law. So subject to restricts and law confers. Now, let me first clear I think it is a confusion which has occurred, whether the term law is used in Article 191 means or includes acts of parliament or not. My lord, in order to understand this, my lord, let us first go to the Supreme Court rules and let us examine how the Supreme Court, full court in 1980 which sat, looked at this term law, and the answer lies in that. If I may take your lordships to the Supreme Court rules, Order 11, which is the critical section dealing with the Chief Justice being the master of the roster. How did they understand this term law? If your lordships have Order 11, my lords. If I may read, and I'll only read the first line, critical line, save as otherwise provided by law or by these rules. Now, your lordship may notice the language in this. Save as otherwise, critical word, otherwise, provided by law. My lord, a bare reading of this provision shows that one is envisaging some kind of statutory law. That if law here refers to act, there may be some other arrangement in some other statute.
Subject to otherwise provided by law, what? Pura padhiye na isko.
By law.
No, kindly read the whole.
Save as otherwise provided by law and by these rules, every cause.
Or by these rules. Or by these.
Or by these rules. Every cause, appeal or matter shall be heard and disposed of by a bench consisting of not less than 3 judges to be nominated by the Supreme Court.
Well, this goes to the of the bench, not who is to sit on the bench.
Sir, I'm not coming to. I'm simply saying, how do we understand this term law, which occurs in Article 191? An indication of that is given in this order. This clearly implies some kind of statutory law, and I'll come to the words otherwise later when I examine what is the relationship between rules and act. Now, to further clarify that the word law must include an act of parliament, there is a definition section in this Supreme Court rules. Now, your lordship may kindly come to that. If your lordships may kindly see order 2.
Mr. Siddiqui?
Yes.
The question was that if it is only to be an act of parliament, then the constitution might have used the word act of parliament, not that the word law includes act of parliament. The whole issue was that subject to law, law is a very broad term,
Yes.
includes many things,
Yes.
including an act of parliament.
Yes.
And the Attorney General said that we should read into the word law the fact that it's just an act of parliament. Hence the issue as to how to read the word law. तो आप जो बहस कर रहे हैं कि लॉ में एक्ट ऑफ पार्लियामेंट है वो तो अंडरस्टूड है, सिर्फ ये है कि टू द एक्सक्लूजन ऑफ एवरीथिंग एल्स हम इसको लॉ में पढ़ेंगे.
The exclusion argue nahi kar raha hu, and the reason I am trying to clarify so that there is no confusion is to come to my argument about conferment under Article 190. If I may just make one point on this.
You see, there are two issues
Yes,
here.
yes.
I interject now.
Ji.
I'm here to hear you. Please conclude your submissions. If someone wants to ask a question, if you start responding to each query, I don't even know what your argument is. And I would request the honorable members of the bench to at least let counsel complete his submission. Yes, there will be questions, but I don't know what you're going to say next. And if you are faced with questions, I mean, I don't know what I'm to write, and I just lose the chain of thought, and I'm sure you do as well. So, Mr. Siddiqui, please, if you keep responding to each question, we'll be forever. No, excuse me, this is no laughing matter.
My lord,
No, from morning to night on the first day we worked, every second of this court is time of the people who have invested heavily in this institution. 3 full days have worked. Now we are on the 4th day. We can endlessly hear one case in the year, and that's our performance. And all the other cases will get left behind, and all mounting up. So please, there are 15 of us, and all of us have questions, and undoubtedly valid questions. Please complete your chain of thought, and if you keep responding, I don't know what your contention is, I will never understand it.
If I may just complete this.
Please keep submitting your submissions.
I'm very grateful to your lordship. If your lordships may see order 1, it contains various definitions, my lord, and then your lordship may see subsection 2. If I may read. Unless the context, now law is not defined in Supreme Court rules, but this provision is there. Unless the context otherwise requires, the General Clauses Act 1897 shall apply to the interpretation of these rules as it applies to the interpretation of a federal act. Your lordships are aware that the term law is a defined term in the General Clauses Act. And this is the General Clauses Act 1897 I'm talking about. If your lordship looks at section 3, subsection, sorry sir.
Order 1, 2, 2 है ना, जरा clear कर.
जी जी.
Order 1 का rule 2 का 2.
जी, rule 2.
जी.
Rule 2 का 2.
जी जी. जी, rule 2 का 2. I'm sorry sir. So the definition of what law means in Order 11 would come from the General Clauses Act. And Section 3, subsection 37B has a definition of law. It says Pakistani law, but the case law consistently says where the term law means Pakistani law, that is what Pakistani law is. And it says Pakistani law shall mean any act, ordinance, regulation, rule, order, bylaw.
Please tell us where you're reading from.
Sir, Section 3, subsection.
Sections to nahi hai.
Sir, General Clauses Act 1897.
Acha, we are still at the rules, ji.
सर रूल तो मैंने आपको बता दिया, ऑर्डर 1 सब रूल 2। अगर आप जनरल क्लॉजेज एक्ट देख लें, आप सेक्शन 3 सबसेक्शन
Subsection
37B,
37. Pakistani law.
so there is, as the Supreme Court which sat while making these rules was clear in their minds.
It says Pakistan law.
Yes, and the case law says that where the word law comes instead, and I've given the citations, I won't repeat them, that Pakistani law's definition is to be used. I've cited that. So, my lord, there is no doubt about the fact that when the word...
This is the book that I have, subsection. There's a note here saying that this was substituted in 1981.
Ji. Sir, 37B.
Yes,
It was substituted in 1981, what you are reading. So when the full court sat to frame the rules in Supreme Court Rules 1980, what was 37B then?
But it would still apply.
No, but what was it?
I'm not aware of that, but
Check.
yes. So, my submission before your lordship is that even if one looks at the structure of the sentence, save as otherwise provided by law, the contemplation mind of even while framing the rules is that there can be an act of parliament. Now, what is the relationship between that act of parliament and the rules? That is a crucial question. But there can be no question about the fact that rules, act of parliament can be on practice and procedure of the Supreme Court.
No, it can't.
So that's my first point.
Just a moment.
Ji,
You
sir.
First of all, you are asking us to read a definition which does not say law but says Pakistani law in the specific context of Article 191 and the Supreme Court rules. Okay, that's your argument. But you say that law...
I don't know what you say. I still have to note it. Can you please complete your thought? So let me understand what you're saying. So then the question, I will understand the question also. If you're not so quick at understanding, can you please complete your submissions from your own mouth? Let us hear it.
My submission is that the word...
Let me first ask up to whatever you said
Please,
now.
can you I don't know the question has to follow a submission. Please, can you conclude your submission, Mr. Faisal Siddiqui? Otherwise, we'll have to spend forever on this case.
Sir, may I...
आप जरा अपना conclude कर लें submissions.
May I just... Thank you, sir. Thank you. Sir, my
I
submission...
can't follow what you're
Yes,
saying.
Sir, my submission is that the word law, as it occurs in Article 191, includes acts of parliament. And an indication of that, a clear indication of that is given in the rules as framed in 1980, because the language, for example, used in Order 11 talks about save as otherwise provided by law. That clearly indicates that one is talking about statutory law.
Okay, next point.
Yes, yes.
Just before you
And
carry on,
that of course is buttressed by the definition.
Just before you carry on
Ji,
to
ji,
your
sir,
next point,
ji.
I think, if I may ask, in the 1956 Constitution, you will recall that there was a specific article which said that words and phrases not defined in the Constitution shall have the same meaning as in the General Clauses Act.
Yes.
That was in the 1956 Constitution. Is there any equivalent in the 1973 Constitution? As far as I can
I don't-
Mr. Faisal
I-
Siddiqui, you have
I'm
been
not
right.
aware of it.
You have been rightly stumped. Please persist
Therefore,
with your submissions.
Therefore, my question to you is that here we have to look at the word law as used in Article 191, because the rule-making power is conferred by Article 191. So any definition, anything that goes in the Supreme Court Rules 1980 has to be consistent with the language of Article 191.
I'll come to that. My short answer.
you focus on that.
Yes.
What does law mean over
Yes.
there?
My short answer to that.
I think council.
Sir, I'll just complete
no,
my
I
submission.
think council is entitled to argue any which way they want to.
Achha.
Let us hear you.
Yes.
I have to hear you decide what you say. And if we have already formed opinions, we can reflect them in our judgments. Please
Not a
continue.
question-
Otherwise,
I'm
we
sorry,
will
this is
never
not a question
conclude
of
these
forming
hearings.
An opinion. This is a question that as a judge of the court sitting on this bench, I'm entitled to
Of
ask
course,
counsel.
ask it. Let the
So I'm
council
asking the
finish
coun-
his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the
I'm
interruption
asking-
is of
I'm
learned
asking-
council.
I'm
Chale
asking
learned council,
counsel-
aap aage बढ़ें.
I am asking counsel a question, which is my right to ask the counsel. If he wants
upon, but at the same time, there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expansive. It says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is a legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58 read with 191 gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. So, but what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
I bow to your lordship. That is why I said it's a ping pong entry, and that is what happens when you look at entry 55. My position is very different from Mr. Salahuddin's
ping
position.
pong can go on endlessly. Where does your ping pong end?
I'll come.
I think it's
it's
just
a
one
term
way,
you-
it doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would have understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal? As you had mentioned earlier, so that's why, is there any significance of the word practice and whether intra-court appeal passes for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhail who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court
yes,
also,
I
which
can.
are...
But let me just read those because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked what is your opinion. Without my opinion, it was said to.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म होगा तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhail's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar Rizvi. Very interesting opinion, my Lord, page 12, if your Lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the humble opinion that Article 175 of the Constitution, by its clause 1, ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of Section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184(3), there is no bar that a right of appeal through a statute cannot be provided. Now, your Lordship may note 2 things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number 2 is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhail had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the law reforms ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge,
Sorry?
Referee
As he referee judge, sir. Page 20, sir. I may read. Para 3 measure of context de do. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184(3) of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislature? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
If I may request you kindly read the whole.
Should I read the whole, sir?
I think
Ji,
that
ji,
may
ji, ji.
provide
But,
some,
ji, sir, ji, sir.
some background.
But of course, the ordinance was not just an amending statute. It also had section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its spirit and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the in this list, all courts including the High Court. Right of appeal can for present purposes be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in respectively the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of course, contained specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it's saying.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, and it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading.
Which actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision,
yes,
given in the first instance by one member of the court. Then the first as well as the second decision remains the decision of the court. And if you look at Order 5 Rule 2 in the rules,
yes, there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration, yes, to a 3-member bench. So three judges, if you see Order 5 Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an intra-court appeal.
Rule 3, Order 5, Rule 3 says appeal.
Rule